right. Hello, everybody, and welcome to the live stream. I'm Bradley Chaplick of Horlick, Levitt, Lella, and I'm a condominium lawyer. And this is our last live stream, Ask Us Anything of 2020. So I'm here to answer your questions, and we don't have any questions yet in the chat, but we did want to welcome you here, and for those of you who have been with us since March. So thank you for all the support and all the views and all your questions. I did have a few topics that I wanted to discuss while we wait for the questions to come in. So one of the first topics is what to do if your condominium building is in lockdown. So that would be buildings in Toronto, Peel, now York Region, and Windsor. So for those of you up north of Steeles and you're in the lockdown, let's go over how that's going to affect your condominium community. So first thing you want to do, I'm just checking my notes here, is you want to close all your amenities that are indoors. So that includes gyms, swimming pools, sports courts, meeting rooms, anything that's an indoor amenity you want closed. Outdoor amenities, there are some that can remain open, but strict health and safety protocols have to be followed. You need a written safety policy, reservation only. You need to keep people's contact information for tracing purposes and maintain a 2-meter distance between people who are not members of the same household, 3 meters for sports activities. So even your outdoor amenities are going to be pretty limited. And then outdoor gatherings are limited to 10 people in lockdown. Indoor gatherings, of course, just restricted to members of the same household. In-person board meetings and in-person meetings of owners are off the table if you're in lockdown. Short-term rental bookings, there's a timing rule. So if they're made, if the bookings were made before a certain date, they can continue regardless of when the actual reservation takes place, but there can be no new reservations. So that's how the short-term rental booking works. And then in-person real estate showings are permitted by appointment only, but not open houses. So the question that people have is whether you can have in-person household services such as house cleaning, non-essential repairs, renovations, and all of these things are permitted in lockdown. But some condominium corporations will want to create their own policies that restrict people's rights to have household services. And really that's where the individual choice for condominium boards comes in, which is, do you want to have a lockdown policy for your condominium building that is more strict than the actual lockdown emergency order of the provincial government? And you can do that as long as you're acting reasonably. And if you have questions about things that you might want to restrict, like, for example, restrict how deliveries take place or what kind of visitors people can have, then you want to discuss that with your condominium lawyer and craft a reasonable policy that's appropriate for your condominium. So we have a question here from Tova. Would you have the website for the COVID-19 lockdown on gyms in condos and fines if open? I would have to check what the maximum fine is, but the website, okay, if you have our weekly FAQ, so we sent out an email reminding people about this live stream. That email went out yesterday. In that email, there's a big blue button that you click on that says, click here to download our latest FAQ. And in that FAQ, there is a link to the PDF of the 5-color framework. But basically, if you just go into Google and type Ontario emergency orders, you'll get the website right away. And it has all of the COVID-19 lockdown information on it, all of the 5-color code system. It's all widely available. But yeah, we have links to it in our FAQs, in our emails, And you can also just Google Ontario Emergency Orders COVID-19. You'll get the website like top hit right away. So yeah, Tova, let me know if you're having trouble finding the information. Send me an email. I believe my email address is in the video description, and we'll make sure that you get the information you need so you can see how it works. But I'm not sure what the fine would be for having your gym open. Your gym should be closed, so it shouldn't matter what the fine is. Okay, so that's what I wanted to talk to you about. With if you're in lockdown, you want to make sure that you have all of those things covered. And you can watch the Case Law Corner video also on this channel by Paneet on the Fraser case if you want to know more about creating policies that are more restrictive. So that's what I would say to that. And then the other thing I can talk about while we're waiting for some more questions is the Ontario Auditor General's report on condominium oversight. So some people have described, I think the Toronto Star said it was like a scathing report. I didn't find it to be scathing or anything like outrageous. It says a lot about the condominium industry that for many of us were things we already knew, right? We already knew that owners' maintenance fees go up quickly within the first couple years, and that owners are not prepared for these kinds of increases, and people find them surprising, and that there's insufficient disclosure for pre-development, all these things. For people in the industry, we knew all this stuff. So none of this was shocking, but there were some interesting things relating to director training and manager licensing, which I thought were particularly interesting revelations, as well as the outcome of the unit owner survey that the Auditor General's office did. So I want to talk about some of those findings. So the first interesting finding was that on the Condominium Authority website, there is a public directory. And in that public directory for Ontario condominium corporations, it has contact information for the managers. So you have the board members, and then you also have the manager contact info. And what they found was just the names of condominium managers that people provided, like just to say, here's our manager. There were 316 people listed publicly as condominium managers who were not licensed. And there was no checking. There was no between the CMRAO, the Condominium Management Regulatory Authority, and the CAO, the Condominium Authority. So someone would write in and say, so-and-so is our manager. It so happens that that person is an unlicensed and therefore illegally practicing condominium manager. And the CAO was not flagging that and reporting it to the CMRAO or checking to see if the person had a license. And now they do as a result of this report. And we know that because we have people coming to us saying that they got flagged for being an unlicensed condominium manager because their name was put down as a condominium manager in the CAO public registry. So that was something like a real substantive change to the way condominiums work as a result of the Auditor General's report, which is now the two organizations talk to each other. And if you put down the name of someone in your directory who's a condominium manager who's not licensed, they'll catch it. So I thought that was interesting. I also thought it was interesting that there were over 300 people practicing holding themselves out as condominium managers who didn't have licenses. I thought that number seemed high to me. I would have thought the real number would have been like less than 100. Okay, so that was thing number one. Thing number two was that approximately 17% of condominium directors were not completing their training within 6 months of being elected or appointed. So these are new condominium directors who have to complete their training, and 1 in 6 basically is not doing it. And I guess that's not really surprising because to me that's consistent with the fact that many people don't realize that they have to do the training, and the problem comes up repeatedly in the practice of condominium law of people coming to us after they've missed the 6-month deadline and asking what is the consequence of their failure to complete their training within 6 months. And the sad consequence is that you're no longer a director. So it's like you got kicked off the board, and you can't just remedy it by completing your training and saying, okay, now it's fine. You missed the 6 months, you're out. So even the people who then complete the training late, they can be reappointed to the board, but they would still have to be reelected at the next year's annual general meeting. So I thought that was really interesting that like 1 in 6 directors doesn't complete their training within 6 months. And then there was the Auditor General said that the CAO used to notify directors if they hadn't completed the training to say like, hey, you have to stop acting as a director, but they were told by the Ontario Ministry of Consumer Services to stop doing that, which I thought was really interesting. Because we used to see those emails, right? The emails would come in and the CAO would write to a director and say, you didn't complete your training within 6 months, you're no longer our director. And then we stopped seeing them, and then this is why, because the government had directed the CAO not to send them out anymore. But the consequence of doing that was that people didn't realize that they hadn't completed their training, and so they kept acting as directors. And so I was really curious as to like what was being achieved by no longer telling people that they were actually not directors, even though they thought they were. So I would have let the CAO keep sending the emails, right? People aren't directors, they should know about it. You don't want people doing stuff without authority and not realizing it. So that was interesting. The CAO also asked for permission to flag directors who didn't complete their training, like on this public registry. So like if you were a new director and you didn't complete your training within 6 months and then you went and searched on the CAO public registry, like a little note would come up next to your name saying like training not completed, removed from board. And the Ontario government said, no, you can't do that. I thought, again, that was really interesting. So like the CAO was trying to make the rules enforced and they were being stymied. And so the question is why? Why? Why weren't the rules being enforced? What was the reason for saying that they couldn't do these things? Very interesting. So then on the quality of the director training itself, more than a quarter of the people who completed their director training did so in less than 3 hours, which indicates that they probably didn't fully read the materials, because it does take about 3 to 6 hours to read the materials fully. So again, and why were people able to complete the training in less than 3 hours? Well, because there was no timer on each of the slides. So sometimes if you do online training, there's a timer on the slide that prevents you from clicking forward until a certain amount of time has elapsed to basically force you to read it. And the director training didn't have that, so you could just click through the slides and rush through the materials in less than the recommended amount of time. And then they found that a large number of directors were doing that. They were skipping through at least half of the modules. And so again, like this, we need enhanced or enriched director training, and the CAO has come forward and said they're going to make changes to the training program so that you're going to learn more, you're less likely to skip through it. But I had not done the director training, so I didn't even know that this was possible, that you could just skip through it. But of course, if it's possible, people would. I mean, it's totally natural that if you don't force people to do it slowly, they'll do it as quickly as they can, because why wouldn't you, right? So again, this is all thanks to the Auditor General's report that these things are coming to light. There's no government database that tracks which condominium corporations are residential, commercial, or mixed use. This was not a surprise to me. This was a problem that many people wanted fixed when the Condominium Act was amended in 2017, and though it just wasn't done. But a lot of people wanted there to be a registry, or for condominium corporations that were residential to have that somehow indicated in the name of the condominium, or publicly available information, because it helps for planning purposes because we know that there's 11,000 and something condominium corporations in Ontario, but we don't know which ones are residential or not. I mean, you could go condo by condo and check their declarations, but you would like that information to be publicly available for planning purposes, so that if you say to a municipality, oh, in Middlesex, like London, Ontario, you've got 500 condos. They would want to know, well, how many of them are residential and how many units, and are they large or small, so that you have some sense for planning purposes as to what you're dealing with. So that problem is still not solved. There's no solution to that problem. Maybe someday we'll have a registry, but not yet. The next thing had to do with expanding the jurisdiction of the Condominium Authority Tribunal. So, as many of you will know, the CAT, Condo Authority Tribunal jurisdiction, was expanded as of October 1st to include disputes with respect to pets, parking, vehicles, like driving on the property, and storage lockers. So, I mean, I get the connection between parking, vehicles, and storage, but pets is sort of its own thing. And the question came up, which is why these types of disputes? And on the Auditor General's survey, she asked, what is the most common type of dispute? And so she, what kinds of disputes do condominium unit owners have with their condominium building? And pets, parking, vehicles, and storage were not in the top 5. So they weren't even anywhere close to the most popular or most common types of disputes. The most common type of dispute was common element repairs. So something wrong with the building, causing damage inside of a unit, and owners going to the condo and saying, I need this fixed. So if you were going to create an expanded jurisdiction for CAT, why not deal with that, right? Why not deal with common element repairs? And then you're capturing something that's actually the most important issue for unit owners, as opposed to pets and parking, which, yeah, there are some disputes relating to pets and parking, but not that many. So why was it this particular kind of dispute? What was the reason for it? Clearly it wasn't based upon like need, it was based on something. Maybe they thought it was manageable, but common element repairs probably would have been a better choice. Another common dispute, which also would have been a good choice, is noise disputes and smoking. Those are very common. So we still just have the one question from Tova. Oh, here comes another one from Francis Reed. So, and that concludes my sort of report to you on the highlights of what I thought was interesting from the Auditor General's report. But if you're into this kind of thing and you want to read the report, it's 80 pages long. It's a little bit dense, but it's organized fairly well, and you can skip through to the topics that are most interesting to you and have a read through and be reminded of all the things in the condo industry that need to be improved. Okay, so Francis asks, a new owner completing a renovation in order to move in to the unit, missing kitchen? ? The board permitted within COVID-19 renovation restrictions to comply. Residents are mad. Last date of work, December 24. What is your question, Francis? Could this lead to a legal issue? What do you mean? I don't. I'm having trouble understanding the question. The unit owner is completing a renovation in order to move in. The board permitted the renovation with restrictions. Residents are mad. Last date of work is December 24. December 24, 2020 or 2019? I'm not sure what's going on here. There's nothing that says people can't do renovations in their units right now because of COVID. It's not a law. Francis, it seems to me that there is some sort of serious legal issue going on here with respect to whether the new owners should be permitted to complete their renovation and move into their unit. My suspicion is that they should be allowed to, unless there's a really good reason why you wouldn't let people complete a renovation. Oh, it's noise. Okay, so look. So the problem, Francis, if the problem is because of noise, um, then you make rules about noise, and you say you can only do noisy work during certain hours. You have to stop at 5 p.m. Not on Sundays, not on Christmas Day, not on statutory holidays. You put in reasonable restrictions, but you can't just tell someone to stop the renovation completely and not let them move into their unit. So I think if you want to make reasonable restrictions because of noise, that's fine, but you don't say no renovations because the law does allow people to do renovations right now. And yeah, it's bad timing because people are going to be home for the holidays, but it's not like we were in the spring when everyone was at home and people were working from home exclusively, and because of that, people were saying, well, we don't want to have noisy renovations because it's disturbing people's right to work from home unless it's an emergency. So Francis is saying they're complying 10 to 4 p.m. So I think that's great, Francis. It looks like you guys have done exactly what I would have said. So there's a renovation going on. There's noise problems. The work has to be done during 10 to 4. Boards put a reasonable restriction on it. Owners are complying. That's great. So I think that looks good, Francis. And yeah, as long as the restrictions are reasonable, I think the court will be supportive of condominium corporations, but you have to be reasonable. You can't just be draconian in your rules. All right, so thank you. Okay, great. Dreadbane asks, are there any general notices sent when specific managers or management firms are no longer licensed to practice? It should be more common. So if you go to the CMRAO's website, you will see that they have a section on enforcement, and you can see if there are ongoing court proceedings or disciplinary proceedings for licensed condominium managers and management companies. But other than having a notice put on the CMRAO's website, I'm not aware of anything. So I hope that answers your question. But you can definitely go on the CMRAO website and see notices posted there for managers and management firms that have had compliance action taken against them. Yeah, especially if it's before the courts, they'll tell you that it's before the courts. All right, Cheng Wang asks, can the board prohibit no in-suite renovation during lockdown, such as kitchen cabinet replacement and backsplash replacement? So this is a good question, and it's something that very similar to what Francis asked. So first thing is the lockdown itself permits in-suite renovations. So the fact that we're in lockdown does not mean that renovations must stop. And then at the same time, there's a case called Fraser, which we did a Case Law Corner video about, which says that when you have a lockdown or any other emergency order, a condominium corporation can implement policies that are more restrictive than the emergency order. So you could have rules about renovations, but I don't think you could prohibit all renovations. So consider the scenario of someone painting in their unit where it doesn't create any noise, it doesn't disturb anybody. In my view, it would be sort of unreasonable to say we're not going to let people paint their units or whatever because of lockdown. Because what's the harm if the people are following health and safety protocols, they're wearing masks, and it's no different than anyone else coming into the building to let a painter in, and it's not making any noise that disturbs anyone. So in that circumstance, you have to think, what's the harm? But if you're talking about something that's really noisy, like Francis was, restricting the hours and the days when renovations can take place, so you would say no weekends, no early morning, nothing after 5 p.m., no statutory holidays, and especially over the sort of the last couple weeks of the year when people are mostly off work and at home. So those types of things I think would be reasonable. If the board wanted to be more restrictive than that, you would need a really good reason. So I hope that answers your question, Cheng, about in-suite renovations. It's a good question. It comes up a lot. And I don't think that there's one clear answer. I think it's really going to depend on your circumstances. So we talked about the lockdown. We've talked about the Auditor General's report. We've talked about can we be more strict. Let's talk a little bit about HLD meetings and then I've really talked about all the things that that I have to talk about. So we've been doing HLD meetings now since, I guess, like end of August, and so September, October, November. Now we're into December, and we've done hundreds of meetings, and we've learned a lot from them. So some of those first couple meetings were learning experiences, but I think our firm's really got the procedure down pretty tight now, and we expect to continue doing virtual meetings for most, if not all, of 2021. And so if you're thinking about your 2021 AGM, maybe your meetings are normally in the first few months of the year, January, February, March. You can basically guarantee that you're going to be having a virtual meeting of owners. It's not going to be in person, and you should start thinking about how you're going to do it, especially if you haven't had one yet, because maybe your meeting's in February, and last year you got your meeting in under the wire, and now you're doing your first virtual meeting. And if that's the case, you're one of the lucky ones, because you will benefit from the experience of others, right? All the other thousands of condos that had to have virtual meetings in the fall. Now, if you're doing it in the winter for the first time, you're benefiting. If you also did it in the fall, then you know what to expect, right? But if you're doing it for the first time, we put up a video on this YouTube channel. You should check it out, and it explains for condominium managers and also for boards of directors if you're interested, but really for the managers, how to organize a virtual meeting and what to do after you contact us, you book the meeting date, and what each step by step is going to happen next. And so I would really encourage you to check out that video if you have questions. Once again, Paneet did that video. She did a great job, and she explains each of the steps for organizing your virtual meeting. Common questions are things like, what if I don't have the internet? You can phone in, right? How do we vote? Are you still going to allow proxies? Yes, all these types of questions. So we're still doing HLD meetings. It's very busy. We've got fixed prices for meetings up to 2 hours, and we usually are asked at the same time to pass an electronic meetings bylaw, which you can still pass up until May 31st, 2021. You can have your meeting electronically without a bylaw, pass your bylaw before May 31st, and then if you need to have another meeting after May 31st, 2021, you've got your bylaw in place and you're ready to go. So if anyone has any questions about that, I can answer them, but we've got our videos up there. So that's what's going on for 2020. And it's really all I had to talk about. I wanted to talk about what's going on in lockdown. I wanted to talk about HLD meetings and remind people to get their bylaws done before May 31st, 2021, and to let us know if they've got questions about meetings. So before we sign off, I will mention, because I don't see any questions coming in, I'll mention one more thing, which is a reminder to continue with health screening every single day for employees in condominium buildings. So this was something that was brought into effect in September. It is still enforced. You still have to be doing this. And I'm not sure that everyone is doing it. So I'm reminding you, you are required to conduct daily employee health screening for people who work in a condominium setting. It's true for people who work in all employment settings, but it includes condominiums. And there is a standard screening questionnaire that you can get from the City of Toronto or from the Ministry of Health from Ontario. And who does this apply to? So if you've got on-site property management, superintendents, custodians, cleaners, security staff, even couriers or delivery workers who are making deliveries to the condominium corporation, they should be asked to fill out a health screening questionnaire. Anyone who works for the corporation on a volunteer basis, and anyone else who is working on site, such as your landscapers, maintenance, repair contractors, plumbers, electricians, all these people should be signing health screening questionnaires when they come into the building, confirming that they don't have any symptoms, they haven't been in contact with anyone, they haven't been asked to self-isolate within the last 14 days, they haven't traveled outside of Canada. These people are going to fill out that questionnaire. They're going to say no, 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 no to all those questions, and then they're going to be allowed to proceed to go to work. And if they answer yes to any of those questions, so they say, yes, I do have a fever, send them home and direct them to public health and to self-isolate. And that's especially important for those of you who are in lockdown, that you're very strictly following this health screening questionnaire and you're making sure that you don't have people come into work sick, because it's a big problem. You don't want to have an outbreak among the staff in your building, because you're going to get public health involved, and then they're going to be asking if you did the questionnaires, and if you didn't, you're going to get in trouble. So that's really it from me today, and keep an eye out. We'll be back in January with the 2021 FAQ, with our 2021 videos. We haven't decided exactly what the format of the videos is going to look like for 2021, but we do want to keep people informed and answering all your questions for as long as we're having health emergencies and emergency orders and rapid changes in the law, and gradually as people start to get vaccinated and this thing subsides and the orders start to get loosened, people will have questions about how to go back to normal and what that looks like, and we'll be here to answer all those questions. And for any of you who are concerned about vaccines, while I am not a health expert, I can speak from my family's personal experience that my lovely wife is a medical professional. She works in nursing homes, and she gets vaccinated today. So I'm very proud of her, and I want to thank everyone for all the work you're doing, all the condominium managers and directors out there who volunteer their time, who've had a challenging year. We want to thank you all for your hard work, and we appreciate it. And these live streams and FAQs and emails and all the information that we put out is our way of saying that we see you, we appreciate you, and thank you for what you do. So I hope you have a happy, healthy, and safe rest of the year, and we will see you in January. See you later, everyone. Have a good